Matrimonial property law on Indigenous reserve land is a complex area of law, which involves constitutional division of powers, family law, Aboriginal law, and Indigenous self-governance. There is a serious lack of knowledge by lawyers, judges, and the public regarding this area of law. Matrimonial property law on reserve has a history of problematic court decisions and persistent legislative gaps. The current legislation has potential challenges and opportunities, including the opportunity for exercising Indigenous self-governance. Matrimonial property law on reserve was discussed by the Supreme Court of Canada in the 1986 decision Derrickson and Derrickson. The case involved a divorcing couple who were both members of the West Bank Indian Band and held certificates of possession to property on the reserve. The wife sought a one-half interest to the properties for which her husband held certificates of possession under the BC Family Relations Act. The court determined that provincial matrimonial property law cannot apply to the right of possession of Indigenous reserve lands. The right to possess lands on a reserve falls within the exclusive federal constitutional jurisdiction over Indians and land reserved for the Indians. There are two pieces of legislation competing to apply in this context: the Provincial Family Relations Act and the Federal Indian Act. While the Provincial Act states that each spouse is entitled to an undivided half interest in each family asset upon the dissolution of marriage, the Federal Act states that reserves are a federal responsibility, with the Governor and Council given the power to determine the use of the land. The two acts are in conflict. Any conflict between a federal statute and a provincial statute must be resolved in favor of the federal statute. While no order for property division can be made on reserve lands, an order for compensation in lieu of division of property can be made because there are no conflicting provisions in the federal legislation. This court decision was the subject of much critique. As explained by Mary Ellen Turpel, framing the issue in constitutional division of powers doctrine is an effective strategy for depoliticizing the case and silencing any questioning of the overwhelming state control of jurisdiction over Aboriginal peoples. Since there has been a strong trend of issuing certificates of possession in the husband's name, this decision has disproportionately harsh consequences for Indigenous women. It has particularly troubling consequences in situations of family violence. This case has also been critiqued for mischaracterizing the value of land. As explained by Mary Ellen Turpel, the economic value of land is secondary to its value as shelter within a larger homeland, the homeland of her people, her family. Rather than being perceived as a commodity, the reserve is a community of extended families, tightly connected by history, language, and culture. Indigenous women are also forced to accept an alien system of property allocation, since there is no place for customary law in matrimonial property disputes. 27 years after the Derrickson decision, the federal government passed the Family Homes on Reserves and Matrimonial Interests or Rights Act, which came into effect in 2014. This act creates a default matrimonial property regime on reserve. First Nations can opt out of these rules at any time by legislating their own matrimonial property laws. The act applies where at least one spouse or common law partner is a member of a First Nation or an Indian under the Indian Act. Common law is defined as a conjugal relationship with cohabitation for at least 1 year. The Act provides protections and rights to individuals on reserve during a relationship, when a relationship breaks down, and when a partner dies. Each spouse or common law partner may occupy the family home during the relationship, whether or not the person is a First Nation member or an Indian. A spouse or common law partner is entitled to a presumptive equal division of the value of the family home and any other matrimonial interests or rights upon relationship breakdown. The courts can enforce agreements made between spouses or common law partners on how matrimonial property will be divided. One spouse or common law partner can't mortgage or sell the family home without the consent of the other. After the death of a spouse or common law partner, the survivor may remain in the family home for up to 180 days, whether or not the survivor is a First Nation member or Indian, with the right to apply to the court for continued possession. This act gives courts the power to grant exclusive occupancy to the family home to one spouse or common law partner, grant emergency protection orders that exclude a spouse or common law partner from the family home in cases of family violence, and order the transfer of matrimonial property from one spouse or common law partner to the other. This act presents potential challenges. Accessing the courts to enforce the protections and rights provided by this act may be difficult and expensive for many First Nations communities, especially remote communities. Court orders under the Act may result in increased conflict, since the courts consider individual rights over the collective rights of the community. A particularly troubling result for some First Nations is that there may be situations where band members are denied rights, while the rights of non-band members are upheld. Because of the lack of adequate housing on many reserves, court orders may force First Nation band members to live off reserve. This act also provides potential opportunities. It provides many rights and protections which were denied to Indigenous people, particularly Indigenous women, for decades. This act is significant in its potential to protect spouses or common law partners in situations of family violence. It also provides more flexibility and autonomy in determining rights and protections through enforcing agreements made between spouses or common law partners, provided they are based on consent and not unconscionable. This act is particularly significant in providing an opportunity for the exercise of Indigenous self-governance. As of November 2018, 14 First Nations across Canada have opted out of the default regime created by this act by legislating their own matrimonial property regimes. When First Nations enact their own laws, disputes can be addressed more appropriately, often through the use of traditional dispute resolution processes rather than reliance on the settler court system. Mediation is prioritized, with tribunal adjudication used only when necessary to reach a resolution. The implementation plan for this act did not include direct funding to First Nations for the development of their laws. The Centre of Excellence for Matrimonial Real Property, an arm's-length First Nation organization, plays an important role in providing expertise and support to First Nations, including providing best practices and templates. The Centre of Excellence also has a pilot project to provide financial support to First Nations to increase community member awareness, develop laws, conduct ratification votes, and develop internal capacity and procedures. The problematic court decision, Derrickson and Derrickson, resulted in a legislative gap for 27 years. The Family Homes on Reserves and Matrimonial Interests or Rights Act created a default regime to address this gap. This act presents challenges and opportunities, including the opportunity to exercise Indigenous self-governance. Matrimonial property on reserve remains a complex area of law, with important consequences for First Nations and particularly significant rights and protections for Indigenous women.